Welcome everyone to Greenway Chambers. My name is Garth Campbell and Lucas Shipway and I are going to be presenting today on the Design and Building Practitioners Act 2020, both an update on the latest developments in the area and how to plead and defend a claim for the breach of the statutory duty of care contained in that Act. Now, I'd like to start by acknowledging the Gadigal people of the Eora Nation and pay our respects to their elders, both past and present. Now, what we'll cover in this seminar is a brief history of the law of negligence as it applies to defective building work, the changes that were introduced by the Design and Building Practitioners Act, some recent decisions, and finally Lucas will take you through how to plead and defend a claim for a breach of statutory duty of care, under that Act in Section 37. Now, Section 37, which is the imposition of the statutory duty of care, deals with broadly 4 issues. Firstly, it imposes a duty to exercise reasonable care to avoid economic loss caused by defects in construction work. Secondly, it details who owes the duty. It details who the duty is owed to, and it has something to say about the scope of that duty. The duty is owed by a person who carries out construction work. Now that seems quite broad, and I'll deal with that shortly. The duty is owed to each owner in the present tense and each subsequent owner. And per subsection 3, go back a bit, the provision imposes the duty in the context of the common law of negligence, as if the duty was established by the common law. Now, the context and wording of the section makes it important to understand the common law of negligence as it applies to damage for defects in construction works. And it was traditionally not recognised as a legitimate basis for a claim in negligence. So that's important to understand how that works, because the common law of negligence comes up in circumstances, in particular in relation to cross claims, which Lucas will deal with, and also in cases where the duty of care is applied and how it is applied, the duty of care under Section 37. So what are the basic elements of a claim in negligence? Well, we've got 3 basic elements, being the existence of the duty of care, a breach of the duty, and thirdly, the remoteness or the non-remoteness, if you're trying to claim, for the damage that's been claimed. And it's important to note that the Design and Building Practitioners Act only imposes the first element, the existence of the duty of care. So if you're going to prove a claim in negligence based on that duty, you have to remember that you also have to prove the breach and that the damage was not too remote. Now, historically, there's been a rule that pure economic loss is not claimable. But there was no general test for determining the existence or non-existence of a duty of care. They used to use the principles of proximity and reasonable foreseeability to determine whether or not a duty of care exists. And the duties were generally imposed upon those who followed a calling which required skill and competence to exercise in the calling such reasonable skill and competence as was appropriate. And that's a quote from the High Court decision in Mutual Life and Citizens Assurance Company in Evatt, 1970, 122 CLR 628. Now that led to classes of relationships where the duty of care was imposed, and that was generally imposed on, say, a doctor treating a patient, or an engineer in the context of providing advice, or a solicitor in the context of providing advice. So that's the traditional area in which negligence, a duty of care and negligence was imposed. As I mentioned, pure economic loss was originally not allowed as a basis for a claim in negligence. Pure economic loss was defined to be economic loss which is not consequential upon injury to a person or property. Now, construction defects are pure economic loss because they are built into the project. So they're not damage. Another head of damage that's been called pure economic loss is where the economic loss is due to injury to another person or to their property. So you've suffered loss because of injury to somebody else or to their property. That was also called pure economic loss. And that general rule was established in Cattle and Stockton Waterworks, 1875, an English authority. That was until 1976 in Australia, where the Dredge-Willemstad case came to the High Court. And the High Court found for the first time that there was a duty of care that existed in a case of pure economic loss. So it's worth going through the principles of the case just so that you can understand why they imposed the loss, the duty of care in this situation. So there was an oil refinery, let's say on the left here, that was operated by Australian Oil Refining. And this was at Kurnell. And the Caltex terminal was on the other headland on the other side. And there was a pipe that went from the oil refinery to the terminal. Now, the contractual arrangement was that the oil refinery and the pipeline were owned by OAR, but the oil in the pipe was owned by Caltex. Now, along comes the Dredge-Willemstad, and through a series of misadventures, they cut the pipeline, causing an oil spill and causing damage to Caltex. So here we have a classic situation of pure economic loss. We've got Caltex suffering loss because their oil is spilling into the bay, and now they have to arrange transport for that oil from the refinery to their terminal. And there's the cost associated with tracking all that stuff by road. So they've suffered loss, but it's because of damage to another person's property, OAR's pipeline. So the High Court held that damages for pure economic loss were recoverable in exceptional cases where the defendant has knowledge or the means of knowledge that a particular person, and not merely a member of an unascertained class, will be likely to suffer economic loss as a consequence of their negligence. So it's a specific circumstance, and it's an exceptional case. One of the judges, Justice Gibbs, said in that case, and this is an important quote because it gives a rationale for why there is an exceptional circumstance requirement in the cases of pure economic loss. If a person committing an act of negligence were liable for all economic loss foreseeably resulting therefrom, an act of careless inadvertence might expose the person guilty of it to claims unlimited in number and crippling in amount. For example, if through the momentary inattention of an officer, a ship collided with a barge and as a result a large suburban area, which included shops and factories, was deprived of its main means of access to a city, great loss might be suffered by tens of thousands of persons, but to require the wrongdoer to compensate all those who had suffered pecuniary loss would impose upon him a burden out of all proportion to his wrong. Now, the reason I put this in the slide today is because I want you to think about that in the context of Section 37. And I'll take you to that later. Now, the first case to recognise a claim for pure economic loss in the context of construction work was Bryan and Maloney. And this was a case where a professional builder constructed a house for an owner, and then sometime after the construction, the owner sold the house to a subsequent purchaser. After that purchaser had taken possession, cracks began to appear, and the house, it turned out, was built on inadequate footings, and that was caused by the builder, and there was a loss in value that resulted. So the subsequent purchaser, the second owner, sued the builder in negligence, and the High Court upheld that claim. So it's pure economic loss because the defects were built into the property, and that was what caused the problems. Now, the High Court found that the relationship between a professional builder and a subsequent owner, like the relationship between the builder and the first owner, is characterised by the assumption of responsibility on the part of the builder and likely reliance on the part of the owner. So you've got the responsibility and reliance, and these are two important concepts in finding a duty of care. The High Court also relied on the concept of proximity between the builder and the subsequent owner, so there was a connection there, so they were proximate. They also relied on a policy reason that the builder was better qualified and positioned to avoid and guard against the financial risk posed by latent defects than the subsequent owner. And that is a bit of a foretaste of the High Court's reasoning in the multiplex decision, which I'll take you to, where the High Court found that the owners were not vulnerable. And that sort of gives a bit of a taste of vulnerability there. So now we've got the case of, next slide please, multiplex. Now this is quite an important case in the area because this is one of the motivations for Section 37 being enacted. And I actually worked on this case as a young solicitor. So now it concerned defects in the Chelsea Apartments building, which is pictured there in Chatswood. And defects were largely in the windows in the front section, the sort of curved areas. They let a lot of water in, basically. Now, the building was divided into a hotel on the bottom and then apartments on the top. So there were two stratas that came into being. Strata 61288, which was the commercial hotel on the bottom, and 61287, which was the apartments in the top. And they both commenced proceedings against the builder. Now, the residential strata proceedings settled pretty quickly because they claimed under the Home Building Act. So they had Section 18B to impose their damage on the builder, despite the fact that there was no contract, obviously, between the strata and the builder. But the commercial strata didn't have the benefit of the Home Building Act. And they had no contract, so they sued in negligence. And the question of the negligence was run as a separate issue, and it ran all the way to the High Court. Now, the High Court held that the developer had the advantage of a commercial contract with Multiplex, and so they weren't vulnerable. And so therefore there was no duty of care owed by Multiplex to the developer. Now, based on the earlier decision of Wilcox Street Investments, the court held that there was an anterior step, being that there was no duty of care owed by Multiplex to the original developer. And because of that anterior step, the owners of the strata plan, who were the successors in title to the developer, could not have a greater claim than the original developer. And as a result of that, there was no duty of care owed by the builder to the subsequent owners. Now that obviously caused a bit of consternation because there was no fault lying in the strata corporation. They weren't even in existence at the time. So that was one of the reasons for the introduction of the Design and Building Practitioners Act. There was a number of other reasons that were mentioned in the second reading speech. There was a fire in Melbourne in 2014, you may recall, the La Crosse fire, and that was where some aluminium cladding went up very quickly. A balcony on the first floor, there was a backpacker staying in, and they threw a cigarette into a little bin about this big, and some papers caught fire, and the fire went from the first floor to the 14th floor in 14 minutes. So in this case, though, because of the building codes in Melbourne, there were sprinklers inside the building, and luckily there was no flammable insulation between the cladding and the building, as there was in Grenfell, which is the picture there. After La Crosse, the Victorian Building Authority launched an extensive investigation, and the New South Wales Building Authority did the same thing. And then there was this Building Product Safety Act enacted in New South Wales in 2017, which dealt with the requirement to rectify. But liability wasn't dealt with until 2020, when the Design and Building Practitioners Act was enacted. So, Design and Building Practitioners Act dealt with liability. And by imposing the duty of care owed to each owner and each subsequent owner, they dealt with the issue. Next slide, please. So, and next slide again, please. So we've got the duty of care owed by both as a part of Section 37, subsection 2, which specifically says it's owed to each owner and the subsequent owner. So, who is it that owes this duty? A person who carries out construction work. It looks to be quite a broad imposition, especially when you consider the traditional view that it's only qualified people in which reliance and trust is placed that will be subject to a duty. There are a lot of people that carry out construction work that may not be thought of as qualified. So what does it actually mean? So we go to the definitions. Construction work means building work, preparation of regulated designs and other designs, manufacture or supply of a building product, or supervising, coordinating, project managing, or otherwise having substantive control over any of those things. So again, it seems quite broad, but it does depend on the definition of building work. What is the definition of building work? Well, building is the same as the definition in the Environmental Planning and Assessment Act. So we go to the Environmental Planning and Assessment Act, and we find that building is defined essentially to be any structure that's not a mobile home or in part of a structure. So again, very, very broad. There's also another definition of building work in Section 4 of the Act, so that makes it a bit complicated. We've got two definitions of building work, and this one's a bit more active. It actually goes out and sort of says what's being done. We're talking about work involved in coordinating or involved in coordinating or supervising one or more of the following: construction of a building of a class or type prescribed by the regulations, making of alterations or additions, repair, renovation or protective treatment of a building of these types. Now, at the time the Act came into force, there was no regulation. That's subsequently been fixed. Now we've got regulations which say, for the purposes of this section, a Class 2 building, an apartment building, is covered. A Class 3 building, residential buildings other than houses and apartment buildings, or a sole dwelling as a part of a non-residential structure like a caretaker's lodge, something like that, and a residential care building. So those specific buildings are now covered by this provision. But again, the question remains, in the context where we've got another definition, which merely says it includes residential building work and otherwise doesn't have anything to say, what is building work? So we got some idea of that from Justice Stevenson in Goodwin Street Developments. He found a very broad definition. He found that the definition of building work in Section 36 applied and not Section 4. And he said that the words building work should be interpreted according to their natural and ordinary meaning. And because building was a very broadly defined term, being any structure, essentially, that's not a mobile home, building work was also very, very broad. Now, that went to the Court of Appeal, and the Court of Appeal, again, found it very broad, but they did it on a different basis. They said that because building is defined very, very broadly, and building work is defined inclusively, the definition in Section 4 does apply, but it only applies in that active sense the active words of that definition apply, and the building itself part, which in section 4 is class 2, 3 or 9, is now being replaced by the building definition from the Environmental Planning and Assessment Act. So if we go to the next slide, that's what it looks like as a result of the Court of Appeal decision. Building work is work involved in coordinating or supervising work involved in one or more of the following: construction of a building, making or alterations or addition to a building, repair, renovation, etc., etc. And finally, includes residential building work. That's per section 36 definition is added. So that's how it turns out. Again, very, very broad. So we've got part D of the definition from section 36 of construction work: supervising, coordinating, project managing, or otherwise having substantive control over the carrying out of any building work, design work, etc., manufacture or supply. Pretty broad. Applying that definition in Goodwin Street developments, where we have a situation where we have Mr. Roberts, who was not the developer, sorry, not the builder, not a director of the builder, but he actually did the negotiating of the contract. He did the supervising of the building work, and he was actively involved on a daily basis during the construction. Then the builder went into liquidation, so the developer commenced an action against Mr. Roberts for a breach of statutory duty of care. Stevenson found that Roberts had carried out construction work because he in fact both project managed and supervised the construction work, which are elements of the definition of construction work under Part D of Section 36. So, despite the fact that Mr. Roberts was not a director, he was not the licence holder, he was not in any official capacity employed by the builder, because he actually carried out the work, he was held to be subject to the duty of care. And that gives you a clue of where this is going, who is subject to the duty of care. In Pathburn, which is another case by Justice Stevenson, he said some very interesting things about the application. He said, Section 36 speaks of a person who carries out construction work, that is, actually carries out such work. Thus, in relation to the first four words of the relevant definition, that's subsection D, control part of the definition, the question is whether the relevant person actually supervised, coordinated, or project managed the work. However, a person could have substantive control out of the carrying out of the work, notwithstanding the fact, at any particular moment in time, the person was not actually doing anything to cause that control to be exercised, provided the person had the ability and the power to control how the work was carried out. In those circumstances, in my opinion, it is sufficient to enliven the definition to establish that a person was in a position where he was able to so control how the work was carried out. That would be a question of fact. Now, that leads to an important question. When do you control the work if you're not there? Because you could be covered. And that is dealt with by the next part of the Pathburn decision, where Stevenson J. found that a director had that control. So now we've got the definition of a person carrying out construction work, including directors. So we're getting a pretty broad section of the building and construction community here is covered. So that's pretty important, because what that means now is that by Section 37, you can pierce the corporate veil. If you've got a corporation, a building company, or any organisation, manufacturer, supplier, that has been involved in carrying out construction work, you've got a claim against them, but they're going under. You can make that claim against the directors personally, because Section 37 imposes a duty of care personally on people involved in the construction industry. Now, to finish off this line as to who is the duty owed by, we have Bulldogs Constructions and Warrumbungle Shire Council, which was a case I was involved with. Stevenson, in that case, found that a person referred to any person, not just a person acting in their own capacity. And we ran that matter on the basis that we had to know, in the circumstances where it appears a person carrying out construction work was very broad. Was it as broad as people acting for other people? Stevenson J said yes. So what that means is when you have a person who is an employee, a subcontractor, anyone down the chain, they are liable or they are subject to the duty of care, as is all of the other people in that chain. And what that means is that in relation to any particular defect, you could have the builder liable or subject to the duty of care, the subcontractor subject to the duty of care, the foreman of the subcontractor subject to the duty of care, and the person actually doing the work subject to the duty of care, all of whom could be liable for any particular defect. And that liability is coextensive. It can cover 100% of the issue. So all of them can be 100% liable for that defect. So it shows you that Section 37 is a very powerful provision and it is very broadly applicable. So we have a large number of people who in the construction industry are subject to a duty of care. It covers everybody. It covers the person packing nails at Bunnings because they are a supplier. It covers the person manufacturing the nails because they are the manufacturer. It covers all of their employees. It covers their directors. It covers their foremen. It covers their managers. It covers everybody. So that means if you are a foreman going to work on a very large construction site, you are potentially liable because you would see or have potential control over everything that goes on at that site. You are liable or potentially liable through this duty of care for all the defects that occur on that site. It can be quite a scary prospect. Now, there are availabilities in relation to vicarious liability, so the employer would be vicariously liable for the actions of their employees. But what happens if the employee goes bust, as often occurs in the construction industry? The employees could still be liable. So that's a bit of a note of warning, I should suggest. And that's even more the case because under Section 39, the duty of care under Section 37 is non-delegable. It cannot be delegated. There is no way to contract out or to get somebody else to come in and do the work and be responsible. That's just simply not possible, which is another reason why every person in a chain is potentially liable. The person at the bottom Next slide, please. Now, what does non-delegable mean in practice? Well, that was dealt with by Justice Ball in the Crown Group Constructions case. And he said essentially what I've just told you, that is, nothing turns on whether a builder actually designed the external walls or delegated that task to an architect. If they contracted to do it, they are subject to a duty of care. And that duty of care is non-delegable, so they had the ability to control that work and they are subject to the duty. He went on to say that, in terms of a practical sense, and Lucas will deal with this a little bit more later, a claim based on a non-delegable duty of care is not a claim arising from a failure to take reasonable care. So the principal who delegates a task, the subject of the duty, is not subject to a failure to take reasonable care standard. They are subject to a failure to ensure that the delegate takes the reasonable care. So that is essentially a form of strict liability in the sense that they can't get out of it by giving it to somebody else in a reasonable way. No matter how they delegate it, if the duty or the task is performed without reasonable care, the principal will be liable because they did not ensure that it was performed with reasonable care. That is what non-delegable means. And Justice Rees took this up as well in the case of the first case of Pathburn in the first instance. And we'll be going through the case of Pathburn in the Court of Appeal shortly, because that was a very important case. But she said that a principal cannot acquit themselves by exercising reasonable care in entrusting the task to a reputable contractor, but must actually ensure the task is done and done carefully. So that's an important statement about what it means to delegate in the context of a non-delegable duty. So we've got a lot of personal liability here. If you are a foreman who goes to work on a large construction site, that can be a fairly frightening prospect. And if you get sued for a breach of that duty, it's non-delegable. There's nothing you can really do about it, but there is a potential to defray some of that liability through proportionate liability. And the proportionate liability provisions are found in the Civil Liability Act, and I'll go through that now. So, under the Design and Building Practitioners Act, under this part 4, it specifically says that the part is subject to the Civil Liability Act, which includes proportionate liability, thankfully. And in Bullis Constructions, that case I was involved in, Stevenson said that because the Act is expressed to be subject to the Civil Liability Act, the proportionate liability regime is the means by which Parliament has sought to address what would otherwise be a rather heavy imposition on, say, any particular person in this chain of responsibility or liability for the entirety of the loss. No, they can point to other people who are also responsible and defray. So if you're the foreman, you can say, well, actually, I didn't do that work. It was the subcontractor. My liability might be 1%, whatever it is. I failed to supervise, but the work was covered up, so I couldn't see it. So that's how Justice Stevenson saw it. But that was before Pathburn in the Court of Appeal. And that case was handed down in December of last year. Now, this is a very important case because what it said in substance was proportionate liability is no longer available. So for all of you who have cases that may be running through the courts right now, where you've said, okay, we might be subject to a duty of care, but if that's the case, then here is our list of concurrent wrongdoers that you should find proportionately liable as well. Our proportion's only 5%. No longer the case. Can't do it. The Court of Appeal, and I have to confess I have a lot of trouble with this decision. What they did, Justice Rees in the first instance found that Section 5Q of the Civil Liability Act, which is the section which says non-delegable duties should be treated like vicarious liability. Justice Rees found that didn't apply, that section didn't apply because the section talks about liability in tort. She said this wasn't a tort, this was a statute. so it didn't apply. The Court of Appeal found that Section 5Q does apply, and that's because if you recall subsection 3 of 37, it said, in substance, this duty of care is imposed as if it is a duty of care in the common law. So they said that that was, in substance, a tort. They then said that because 5Q actually applies, that to allow a non-delegable duty to be subject to proportionate liability was an incoherency or an inconsistency, entirely inconsistent in the words of Adamson, J.A. So they say that the proportionate liability regime is entirely inconsistent with the non-delegable nature of the statutory duty of care under Section 37. Now, the problem I have with that is Section 39 of the Civil Liability Act says nothing in this part prevents a person from being held vicariously liable from a proportion of any apportionable claim. And when you combine that with Section 5Q, which the court found did apply, you've got a statement that non-delegable duties are to be treated as vicarious liability, a statement which says if it's vicarious liability, then the liability of the delegate can be sheeted home to the principal, even in proportionate liability circumstances. The Civil Liability Act seems to have taken account of non-delegable duties within the concept of proportionate liability. So that's why I have a problem with the decision. But as it currently stands, that is the law in New South Wales. So I think there's going to be a lot of cases in limbo. The Court of Appeal case has been the subject of a special leave application to the High Court. We won't know what happens with that until obviously it's heard and determined. And in the meantime, I hate to say it, but those cases where concurrent wrongdoers have been identified and have been pleaded are in a state of limbo, but as currently formulated, there is no basis to claim proportionate liability. So now we have the section on how to, and I'll hand over to Lucas Shipway for that.
Thanks very much, Garth. That's a very helpful introduction to what I'm going to talk about, which is, as Garth said, a little bit of a how-to as to how to plead and respond to a claim under the statutory duty of care. The first slide, please. Thank you. As Garth's indicated, the statutory duty of care is treated under the statute as if it were, for all intents and purposes, a duty that exists at common law. It's widely accepted that the requirements that apply to the pleading of a claim in negligence at common law also apply when one is pleading a claim under the statutory duty. And those requirements are relevantly now embodied in the Civil Liability Act. They have been for some time, since the civil liability reforms of the early 2000s. Section 5 capital B is our first port of call, and that is a provision that's on the slide that says that a person is not negligent in failing to take precautions against the risk of harm unless the risk was foreseeable. That's a familiar test in the context of negligence. The risk was not insignificant, so that's I think an innovation that had its origins in that civil liability reform, in other words, trying to exclude liability for very insignificant risks. And thirdly, that in the circumstances a reasonable person in the person's position would have taken those precautions. Now, these are elements that must be specifically addressed in a pleading of negligence and in a pleading of a breach of the statutory duty. Now, they probably originated, as I say, in Parliament's desire in the early 2000s to discourage actions that were seen as spurious and imposing an unnecessary burden on insurers and others, claims against councils and so on for failing to take preventative measures like putting up signs and guardrails and so on. I think that's perhaps where the language comes from, because the language is expressed in terms of precautions against a risk. Right? So that's a change in the negligence law, because negligence doesn't just talk about precautions, it talks about reasonable care. But in any event, that's the language that found its way into the section, and that has now been treated as in effect a code for the pleading of negligence, so that you have to identify the precautions that you say ought to have been taken, and that a reasonable person would have taken those precautions, and then you'll need evidence that establishes that someone who speaks from an informed position, an expert, for example, can give evidence about what a competent person would have done. Now, that can cause some difficulties when it comes to identifying what exactly it is you say that a person should have done that would have avoided or prevented the defect in a building from coming about, because some defects you might say you could see as arising from a failure to take precautions, but other defects don't have that character. If you put the wrong material on a building, it's not really a failure to take precautions, that's just the selection of the wrong material. If you put up a beam, if an engineer specifies a beam with insufficient strength, it's not really a failure to take precautions, that's just getting the calculations wrong. So there is a little bit of a disjunction, as it were, between the language in this mandatory now requirement in 5B and the sort of evidence or facts that you might be seeking to corral to put together a claim for a breach of the statutory duty. Next slide, please. Section 5, capital D, imposes some further requirements that must be met in order for a claim in negligence to be pretty familiar requirement, that is that there be a factual causal link. And the second seems to be more in the nature of a legal test, that is whether or not the scope as defined by the law should extend so as to capture this particular negligent person's actions. So again, it's necessary to plead out the facts on which that causal chain is made out on your case, and it's usually some lip service is paid to the second limit. There's just an allegation that it's appropriate and not much more is said about it. Thank you. If we look at how that or those requirements have come to be reflected in the case law, one important decision is the decision of Justice Stevenson in Lulatch Developments. And His Honour there said what I've said to you, that is that a plaintiff alleging a breach of duty of care by a builder under the Act must identify the specific risks that the builder was required to manage. Those are the precautions, or those are the risks to which the precautions are directed, and the precautions that should have been taken to manage those risks. It is not sufficient simply to assert a defect and allege that the builder was required to take whatever precautions were needed to ensure that the defect not be present. Okay, so if we go back to our example of an ill-chosen material like a combustible cladding, what His Honour there seems to be requiring is that you identify, perhaps it's the risk of inappropriate cladding being selected, and then you need to say what are the precautions that the builder ought to have taken, or the designer, to ensure that an inappropriate material wasn't selected. You can't just say the building has combustible cladding on it. Combustible cladding doesn't comply with the relevant code. It's negligence for the person who specified the cladding to have specified a cladding which does not comply with the code. That doesn't seem to be sufficient. Next slide, thank you. And so that problem has come up, I think, for pleaders in various cases. In the Crown Group case, His Honour Justice Ball was critical of the pleading in that case on the basis that it was inadequately pleaded because it didn't give proper particulars of how it was said the builder was negligent. The closest it came was the allegation that the builder was under an obligation to carry out investigations to satisfy itself that the cladding was not combustible. So that has the nature of a precaution. The precaution is that you take steps to check that it's not combustible. But look, in that case, the criticism was that the investigations it's alleged should have undertaken were not clear, might have made inquiries about those things, but failed to do so, and so on. But you can see some of the difficulties that can attend trying to plead out the precaution and in that sort of case. In the owners and Brookfield residential developments, the claim was made against the superintendent. And His Honour Justice Stevenson criticised the claim on the basis that no allegation was made as to how it could follow from the asserted fact that Brookfield carried out the role of superintendent, that it performed or coordinated and supervised the work involved in the construction of the building. The list statement made reference to the powers of the superintendent, but contained no allegations to what Brookfield did or did not do under those clauses. So that's the other, I suppose, dimension to this. Garth talked about the need to demonstrate, so as to come within the purview of the clause, that the relevant defendant has carried out construction work. Carrying out construction work can be shown where there has been an exercise of substantive control, but here is an example where merely pleading the power in the contract, the power of the superintendent, has been held not to be sufficient to demonstrate that control. And so again, it seems that what's required is not merely a pleading of the contractual and other facts that give rise to a power and an ability to exercise control, but rather also you need to plead the facts that you say support the allegation that there was actually control over the work. In some factual situations, that's going to be very difficult because the criticism might be an omission, right? A failure by a superintendent to pick up some aspect of the work, the selection of the combustible cladding, for example. That is necessarily an omission. It's a failure to do something, and query whether pointing to all the things that the superintendent did do is sufficient to show that the superintendent had control over the work in the relevant way, so that it carried out the construction work that gave rise to that defect, because that's the test. Thank you. Justice Ball, in that case, identified that what the builder must do is identify the particular actions that are said that a person in the position of the building supervisor, acting reasonably, would have taken. And then you need to allege that had the building supervisor taken those steps, the harm would not have occurred. And so that's the pleading of the causal chain. Next slide, please. In this case, Oxford and KR Properties, the claim was against the director of the builder. The criticism here was that the pleader had used the words ensuring in the pleading. And it's true that Section 37 of the Act doesn't speak about ensuring anything. It speaks about carrying out work. And so the observation by His Honour is of course quite right, that if you merely allege that someone's failed to ensure something, that doesn't properly engage with the language of the section, but again, it perhaps reveals the difficulty we have when we're seeking to plead facts around an omission. Perhaps what's needed is, as I say, clearly articulating the steps that the defendant did take and the powers that the defendant did have, and the circumstances that provided an opportunity for the defendant to take some step, the failure to take the step, and the consequences of that failure. Now, the case didn't engage terribly closely with the problem because, in the end, in this case, the claim against the director failed for quantum reasons. There wasn't sufficient evidence as to the quantum of that flowing from that claim, and so the judge was able to say, there's no point in me taking this analysis further. And so that meant that the court didn't grapple with how the director may have been liable personally. But as you've heard from Garth, there's clear cases to indicate that there can be liability at a personal level, and so the pleading of liability or the facts leading to liability must be clear and engage with the conduct of the person, perhaps on a day-to-day basis, that have given rise to the defect. The company in the KR Properties case, the company was not the delegate of the director. Garth spoke about the non-delegable nature of the statutory duty. There's no suggestion in that case that the company was a delegate of the director, so that issue didn't arise. But it does seem that the principal may well be liable for the action of delegates, whether that's employees of the company or others, including perhaps subcontractors, where a contractor, for example, has subcontracted the building certification task to someone else, then the subcontractor or the contractor may still be liable for that subcontractor's conduct. And in that context, it is a duty to insure, as Garth said. Then what you are saying is that the person who owes the duty failed to ensure that its delegate carried out or did the work with reasonable care. We'll come next to briefly to the University of Sydney case. That is an example where the court found that there was a lack of precision in respect of the description of the steps that led up, in that case, to the installation of combustible cladding on the building. The matter I was involved in was difficult for the plaintiff because the complaint was about a facts and circumstances not known to the plaintiff as the principal, really known to Multiplex as the builder, and related to its dealings with the certification consultant Mackenzie in respect of the decision about materials on the building. But it illustrates the problem that I've referred to, that is that to plead properly, it seems under this Act it's necessary to specify precisely how combustible cladding in that case came to be installed on the building, and why you say that the certification consultant in that case ought to have done something different, what it is they ought to have done, and had they done it, what would have ensued. Next slide, please. And this is the crux of that particular decision. It was clear that the Mackenzie, the certification consultant, appeared hadn't obtained the necessary information about the material that would have told it that it was non-compliant. And the allegation was that it should have taken that step, but the court found that what was needed was something more than that. That is, that there be a pleading as to what would have happened when Mackenzie took that step. So that just gives you an indication, I think, of the granularity that's needed. Next slide, please. So what does that all mean in terms of running a matter, if you're for the plaintiff, then you need to do what I've talked about, that is descend into granularity, identify the defect, identify who you say was carrying out the work that gave rise to that defect, and then identify how it is that that person's acts and omissions caused the circumstances of the defect to arise. If you are defending a claim, then obviously it's the opposite. That is to say, you are going to look at what's been put against you and see if you think it meets that standard. You ask, I think, whether the plaintiff has sufficiently pleaded and evidenced the actions of the defendant that caused the damage. If you think they haven't, then you make a strategic call. You may wish to make a strikeout application. You may decide that the better course is to leave it as it is, because when it comes to trial, you'll be able to show that the facts have not been sufficiently pleaded to enable you to meet the claim. Those calls have to be made on the particular circumstances of the case. The other consideration, of course, for defendants is whether to bring a cross-claim. Now, as Garth says, we now have been told that proportionate liability is not a defence to a claim for breach of the statutory duty. I think that puts into stark relief the need to consider cross-claims if you are the recipient of or on the wrong end of a claim for breach of the statutory duty, whereas perhaps you might have said, well, I'm going to defend that by making a statutory proportionate liability allegation against others. That's now foreclosed, it seems, and so the question then is, well, whether I should cross-claim against others. You should identify who that might be. There might be subcontractors who you can make claims against in contract. There might be others against whom a claim would have to be made on some other basis if you don't have a direct contractual relationship with them. Now, contributory negligence from the plaintiff for actions of their agents and so on, that's one course available. There's also the question of potentially a claim in negligence, but generally speaking, the courts have said that duties are not owed sideways, as it were, on the tree, so that one contractor doesn't typically owe another contractor on the same project. Say an architect doesn't generally owe the builder a duty of care to avoid causing some difficulty that results in the builder suffering some liability. Duties of care will be owed by the architect to the owner, but not sideways to the builder. So that course of action may not be available. Thank you. So just to recap, if you're a plaintiff, the task is to identify the particular person who carried out the construction work and how exactly they carried out that work. You need to work out the basis for the cause of action. You identify the duty and its scope, and we saw the requirement in the Civil Liability Act in respect of identifying the precautions. Identify the act or omission that is the breach of the duty. You need to find and plead out a clear and unequivocal chain of causation from the action or omission to the damage that has resulted. And obviously you need to think about damages. This is all in aid of recovering economic loss, so it needs to be worth the effort. If you're acting for a defendant, then you're looking at what's been put against you by the same measure, I think, and considering cross-claims and doing so early, bearing in mind limitation defences and the like. In relation to what we want you to take away from today, for my part, it's worth bearing in mind that those requirements in sections 5B and 5D of the Civil Liability Act always have to be addressed. It's important, obviously, to corral the evidence to support the elements of the duty of care, the chain of causation. You need to make sure that you're going to be able to have an expert give an opinion to the effect that the conduct fell short of what you'd expect of a competent person in the circumstances. And as I say, you need to get into that granular detail as to how you say the acts and omissions of the defendant caused the defect. And we're currently unable in New South Wales to plead proportionate liability as a defence. So those are the points I wanted to cover.